Welcome to CPE webinar on healthcare reform for large employers. I'm Peter Duncan. I'm with Hub International, and I'm going to be conducting this presentation today. So to make a comment about the scope of this presentation, we're going to walk through the major provisions of healthcare reform as they apply to large employers. We're going to cover some basic information about healthcare reform and then get into some specifics about how the law applies to large employers in addressing the mandate to provide coverage or pay penalties. But I'd like to start with just some basic information about healthcare reform. The law is commonly referred to as Obamacare, or ACA, Affordable Care Act, or PPACA, Patient Protection and Affordable Care Act. Of course, this is all different names of the overall healthcare reform legislation. And this legislation is being administered by three agencies of the federal government: Health and Human Services, the Department of Labor, and the Internal Revenue Service. It's interesting that all three are involved. This law is so significant and impacts so many different agencies and regulations that these three agencies have come together and are coordinating their guidelines and definition of different provisions of the law. So commonly we will see releases coming out from the agencies jointly as well as individually. This is a large piece of legislation that was not completely written in terms of all of the details and guidelines. So since 2010, when the law was written, we have continuously received guidance from the agencies to help us understand how to comply with the law. A lot of those regulations were issued at the beginning of 2013, well over 10,000 pages, and we continue to see guidance and provisions being issued and changes being made to the schedule of implementation. Just recently we received information about a delay in the large employer mandate for a year. So the situation remains pretty fluid, and there are still a number of areas of the legislation that continue to need further guidance. And so it's incumbent upon everyone to continue to watch and follow these guidelines and changes as they continue to unfold. Some key points about the healthcare reform. There's 6 key areas of this legislation. It's major key points of the law. And it starts with an individual mandate that requires all U.S. citizens to have, and legal residents to have health insurance or pay a penalty. So this applies to everyone. For the first time in the individual health insurance market, coverage is going to be guaranteed issued effective January 1st. The law includes the large employer mandate. Either their employer provides benefits and meets the law's requirements around those benefits, or they're going to be subject to penalties. And we're going to go into some detail about that. The law creates state-based marketplace called state exchanges. These exchanges have responsibility for administering many aspects of the law's access to individual and small group health insurance. We'll spend some time talking about state exchanges. The law also introduces premium credits and cost-sharing subsidies for low-income individuals. And lastly, one of the major components of the law is that it significantly expands the eligibility definition for Medicaid, and in California we call it Medi-Cal. Nationally, about 17 million people will be newly eligible for Medicaid. In California, it's about 1 million individuals will be newly eligible for health insurance coverage under this federal program. Let me start with the individual mandate and the requirement that individuals have coverage or pay a penalty. And this begins January 1st of 14, has not been delayed, although other pieces of the legislation as of today have been delayed. The individual mandate requires that individuals have health insurance coverage for themselves, for their dependents, and cover themselves for at least 9 months beginning January 1st of 14. If an individual does not have coverage for that period of time, there will be a penalty. And the penalties are the greater of, in 2014, $95 or 1% of adjusted gross income. And this applies to each individual in the family. It's half this amount for children and an equal amount for spouse. The penalty will be administered by the IRS, so when individuals file their tax returns at the end of the year, there'll be a line item that indicates whether that individual had coverage for how many months during the year, and if not, what the penalty is. The penalty is pro rata on a monthly basis, so if you had coverage for 6 months, well, then the penalty applies for 6 months. And an example of that. The next item I wanted to talk about relative to the law and is the premium subsidies and credits for individuals. Medicaid is going to be now available to individuals with incomes less than 138% of the federal poverty level. Well, you can see on this slide that as of 2013, the individual poverty level is $11,490. So that puts the threshold for an individual's eligibility for Medicaid at about $15,850. Incomes below that level for an individual qualifies them for Medicaid. For a family of 4, it would be $32,500, just below that. That would qualify that family of 4 for Medicaid coverage. Above these levels, between 138% and 400% of the federal poverty level, individuals are eligible for premium subsidies. And the subsidies will vary depending on the income level. They're greater at the lower income level at $15,856. They're going to get about 90% of their premium subsidized, and then that reduces as incomes go up for individuals. And in our exhibit on page 5, we show the family of 4 income range that the subsidies would apply to, $32,499 to $94,200. Now, these figures are based on 2013 federal poverty levels. They'll adjust slightly in 14 when those numbers are released. One of the key provisions of eligibility for premium subsidies currently is that if an employer offers employees an affordable health plan, and affordable is defined by the law, the individuals and their dependents are not eligible for subsidies. This is a pretty important point that employers need to be aware of and be prepared to communicate to employees about. We're going to go into detail about the affordable rules, but basically the employer, large employer, must offer a 60% value benefit plan, and the cost of the employee is no more than 9.5% of their income. If we meet those two criteria, the plan is defined as being affordable, and therefore, if an employee is eligible for that plan, they're not going to be eligible for premium subsidies. The next slide talks about the state-based health insurance exchanges. So the law requires that an exchange be established in every state. There's a couple of different ways that these exchanges can be set up. The first is that a state can establish their own exchange, as we've done in California, or they can enter into a state federal partnership exchange and work with the federal government to establish their exchange, or they can default entirely to a federally facilitated exchange. And there's a mix of this around the country. We're going to see a map in a moment that tells us, well, what are some of the states doing? But the primary function of a state exchange is to act as a marketplace for individuals and small employers to shop for medical insurance and to be provided guidance, information, and assistance in enrolling and selecting these plans. The exchanges also play a very important role in administering the eligibility for Medicare, Medicaid, as well as for the premium subsidies. The exchange will be responsible for taking in the information, qualifying individuals, and then administering the premium subsidies that someone may be eligible for. The exchanges begin their open enrollment in October of this year, and they'll be fully operational by January 1st of 14. On page 7, we see a map of how states are aligning around the different exchange structures. 16 states and Washington, D.C. have elected to create their own marketplace. California is one of those. Another 7 states have moved towards a federal-state partnership where they're combined, that they're working together and setting up their exchange. And then 26 states have delegated the responsibility back to the federal government, just asked the federal government to run the exchange in their state. One state, as of publishing this report, was still undecided. You'll notice at the far right-hand corner of the slide, there's the Kaiser Family Foundation logo. This is where this information comes from, and it's a wonderful site to get updates on healthcare reform, the legislation, and what are some of the latest provisions that have and guidelines that have been issued. So in California, we have established our own exchange, and it's called Covered California. And California is one of the states that has really led in the development of their exchange. There is a website that's up, and coveredcaliforniaca.com. You can go and get information about the state exchange. It's still in its development stage. The amount of information is somewhat limited, but this is the site that will be available to individuals and employers when it's fully operational later this year, certainly for the open enrollment. So the legislation creates, at the state level, a standardization of benefit plans. Bronze, which is a 60% value plan; silver, 70% value plan; gold, 80%; platinum, 90%. The exchanges will also have a catastrophic plan for children and young adults. So what the law and the operation of the exchange does is it provides standardization of benefits within a state. The benefit plans will vary from state to state, as well as the health insurance plans that are participating from state to state. So you won't see the same thing across state lines, but you will, within a state, the plans will generally be the same. There's a little bit of flexibility that can be applied to benefit plans outside the exchange versus in the exchange in California, but essentially they're going to look the same. And the percentages speak to the actuarial value of those benefit plans, not necessarily the benefit. So if you go to the Covered California site, you can look at what the plan designs are for the bronze, silver, gold, and platinum. The open enrollment will begin October 1st, and if an individual doesn't enroll during that period of time, during the open enrollment, they can only purchase during, as a result of a qualifying event at a later date. One of the requirements of the law is that all employers must provide their employees with a notice of exchange by October 1st of 2013. So a model notice has been released by the federal government. It's available to employers. It's about a page and a quarter, not too detailed, not too complex, but there is a requirement that this notice be distributed to employees. I'm going to move now on to some of the employer responsibilities of the law and go over a couple of the general provisions of the law. one of the things that every employer needs to do is determine whether they are a small employer or a large employer. And the reason we need to do this is because of the mandate that applies to large employers. There is no mandate for small employers, but there is for large. And the mandate requires an employer to do certain things or pay penalties. But determining whether you're small and large is not intuitive. There's a formula, and so we're going to take a moment and talk about that formula. The law says that an employer with more than 50 full-time equivalent employees is considered a large employer and subject to the mandate. Now, what is a full-time equivalent employees? Well, what it means is that an employer must look at not only their full-time employees working 30 hours or more, but they must look at their part-time employees. And in looking at their part-time employees, they will be required to add up the total number of hours per month of all their part-time employees and divide by 120. That will give you an equivalent. So in the example on this slide, we see an employer with 35 full-time employees and 20 part-time employees. Those 20 part-time employees are working 96 hours a month, or a total of 1,920 hours. Those 1,920 hours get divided by 120, which is the full-time equivalent of monthly hours, and it results in a full-time equivalent count of 16. So the 35 full-time plus the 16 equivalent full-time adds up to 51. So in this particular example, this employer with 35 full-time employees and 20 part-time is considered a large employer and is subject to the mandate, subject to penalties if they don't do certain things. So this is a very important item to look at to make this determination. Do it as soon as possible because it will guide your actions throughout 2014 and into 2015. Certainly, if you have any questions or need any assistance, CPE staff can help you with this process and help you determine your status. So on this page, we're going to introduce a couple of new requirements that the law brings to employers, and that is a definition of a full-time employee for health care is now 30 hours per week. The law also introduces a new term called variable employee, and this is an employee that is reasonably expected to work less than 30 hours per week. And lastly, there's a definition now for seasonal employees, and they are individuals working less than 120 days a year. So we're going to spend a little time talking about these categories later on, because as a large employer, it's going to be a requirement that each employee be identified and tracked relative to their status, full-time, variable, or seasonal. There's going to be reporting that related to these categories that an employer will be responsible for doing, and we'll talk about that a little bit more in a moment. The law introduces a new waiting period, not less than 90 days, for a new employee to have health insurance made available to them. In California, legislation has been passed and is in place that requires California employers to use a 60-day waiting period. So California's been a bit more progressive in setting up their waiting period requirements. The law requires that health insurance costs be reported on W-2s. There's a 60-day notice requirement of plan modification, so if an employer is going to make a plan change, modify the benefit plan, employees have to be notified 60 days in advance. And the Uniform Summary of Benefits Coverage, which went into effect for plan anniversaries beginning this year, is a standardization form. It's a communication document that outlines benefits to employees in a national standardized format that is now being used. Another provision of the Act is the Cadillac tax that goes into effect in 2018. Now, this is a few years out, but it's a tax on employers whose benefit plan premium exceeds $10,200 for single coverage or $27,500 for family coverage. These numbers will be indexed to inflation over time. While these, depending on the type of a plan an employer has, you can either be close to or not close to these figures. For California, generally an HMO plan is going to be somewhat less than this, and will take a number of years to get up to these levels. However, a PPO plan, many employers are at these levels today. So this is something that needs to be watched and carefully understood, and employers need to plan around the design of their benefit plans if there's a need to avoid this tax. The next item, non-discrimination rules. So the law included a provision that a health benefit plan offered to employees cannot favor highly compensated employees. Now, the details around this discrimination rule, while initially included in the law, have been put on hold. The implementation has been put on hold, and we're waiting for further guidance on exactly what these discrimination rules will be, how will they be applied, and the impact to the employer will be. This is something that a lot of employers are watching closely, looking for the agencies to release guidance on this. So we may see it this year, we may not. It doesn't appear to have been a high priority given all the other things that this legislation needed to address. The regulation was supposed to go into effect in September 2010, but has been postponed. A couple of comments on wellness relative to the Healthcare Reform Act. So there was some recent guidelines issued that indicated a little bit of a change in position relative to wellness programs. So we included a comment here that indicates participation-based wellness programs, an employer incentive amount is not limited but needs to be made available to all employees. Outcome-based programs, and that is where an individual's health status needs to reach or be at a certain level or reach a certain goal, these plans can have a premium penalty that can apply to whether that individual is reaching that goal or not. So for standard goals, cholesterol, body mass, things of that nature, the premium can be set at a 30% penalty to the individual. Tobacco-based programs can shift up to 50% of the total premium to tobacco users. So there's some new guidance on wellness. If you have a wellness program in place and you have incentives built into the program, this is something that you should take a close look at. Make sure your outcome-based programs are designed properly. Now, the big news that was released by the agencies the first week of July is that the large employer mandate, often referred to as pay or play, has been delayed for a year. So this is the requirement that an employer do a couple of things. They either offer a plan or they don't offer a plan. If they don't offer a plan, there's penalties of $2,000 per full-time employee that apply to the employer. There's a credit of the first 30 employees. The penalty is not tax deductible and would be applied to the employer for the full year. So this has been delayed for a year and gives employers some relief around putting into place the plans and the requirements to meet the law. The main reason the agencies gave us for delaying this provision of the law was that the reporting requirements that an employer must provide to the IRS were not fully defined. Guidelines weren't issued. Employers didn't have the information necessary to begin to set up the reporting requirements that the government is going to use to identify whether the employer meets the law's obligation or not, and then may be subject to penalties. So we have some relief that applies and gives employers more time to work on putting into place the reporting requirements. Another part of the mandate for large employer was the penalty that applied if an employer did offer a benefit plan, but the benefit plan didn't meet affordable standards set by the law. This also has been delayed until 2015. If an employer offers a plan but it doesn't meet the affordable test, and the affordable test is the 60% actuarial value plan and not cost the employee more than 9.5% of income. If either of those failed and an employee received a premium credit at the state exchange, the employer would be subject to a $3,000 penalty for each one of those employees that receive subsidy on the exchange. Again, this penalty is not tax deductible and would be administered, it's going to be administered by the IRS. Here again, the $2,000 penalty, the $3,000 penalty have both been delayed for a year, giving employers time to put into place the reporting requirements necessary to support the administration of this act. Again, on page 15 here, just reiterating that the penalty component of the law has been delayed. We mentioned this earlier, that an employer plan is affordable. The employee can elect the employer plan, or they can elect the state exchange coverage. They don't have to enroll in an employer plan. They just have to be given the opportunity to enroll in the employer plan. And if the employer meets the affordable test, then the employee can make a decision, employer plan or the state exchange plans, but the employee would not be eligible for a subsidy on the state exchange. If the employer plan is affordable, in addition to the employee, the dependent is not eligible for a subsidy. Employer plan is not affordable, then of course individuals may be eligible for the subsidies based on their qualifying requirements. So let's go on to our next page. Talks about some of the administration of the plan. So there's some things that employers must do and put into practice, and that is understand some of the new terms and requirements and concepts that apply to employers. Benefit plans now have a 30-hour work week requirement. Seasonal employees are now 120 days or less. Variable employees need to be identified, and they're classified based on the facts and circumstances at the date of hire, that they cannot reasonably determine if an employee will or will not work on average at least 30 hours a week. So one of the requirements of the law is that when an employer has a variable hour employee, don't know whether the person's going to work 30 hours a week or not, there's a requirement that the employer track and report the hours that this individual is working. And they do this through a process of establishing a measurement period for measuring the hours variable hour employees will be working. The employer can select a measurement period from 3 months to 12 months. And whatever period of time is optimal for that employer. And we're seeing most employers are looking at the 12-month period. So a measurement period is established. And then an administrative period is available for the employer to process individuals, variable hour employees that may become eligible for coverage as a result of working more than 30 hours during that measurement period. Administrative period to process enrollment can be up to 90 days. And then the stability period that applies to these variable hour employees. That's the period of time in which a variable hour employee is eligible for coverage following a measurement period. So let me give an example. If an employer has 10 variable hour employees, they're using a 12-month measurement period to track and report the hours worked on by these individuals. And one of the individuals ends up working more than 30 hours over that measurement period. That individual is now eligible to enroll in the employer's health during the stability period following the measurement period. And the stability period, it can be not less than 6 months, not shorter than the measurement period. So between 6 and 12 months, an individual that has worked more than 30 hours during the measurement period is now eligible to participate in the employer's plan during this stability period, regardless of the hours that that individual is working. On slide 17, we give a couple of examples of how measurement period, administrative period, and stability period might be structured for a typical employer, both for existing employees and for new hire employees. This is something every large employer will need to spend some time thinking about, putting into place, and setting up the processes not only to track and report the variable hour employees, but put into place the process of defining your measurement period, your administrative period, and your stability period for the administration of your plan. Again, this particular area will vary a bit by employer. Dates will be different for each employer, can be based on plan anniversaries, can be calendar year, can be based on some business cycles that might apply to the employer. This is something that every large employer needs to look at closely and begin to work on and establish how they will be administering their plan. A couple of other things an large employer will need to do is really take a very close look at your workforce. Ensure that people are classified properly, full-time, variable, seasonal, including 1099 employees. This is going to be a very sensitive area because 1099 employees are not required to be provided with health insurance. But classifying 1099 employees as 1099 is a very slippery slope to avoid providing benefits to employees and will be watched and looked at very carefully by regulators. An employer should take a look at their workforce, their income levels, their employee contribution strategy for their benefit plan, test for the 9.5% of income to make sure that the affordability test is being met and not triggered, and which may result in penalties. Implement the new 30-hour and waiting period requirements as defined by the law, and this is going to require updating of plan documents, SPDs, handbooks. There is a requirement to update your COBRA notice with the exchange notice that was released. And another thing we recommend to employers is that they establish a waiver for employees specific to this law, that employees complete this waiver statement that acknowledges they understand the individual mandate, they understand they've been given an opportunity to enroll in a plan, they understand they may or may not be eligible for subsidies, and get that completed with your next open enrollment and signed by employees. So you have documentation on file, clearly indicates that the employee was given the information necessary to make a decision, and they acknowledge so. A couple of other things that an employer needs to be aware of, and we mentioned some of these earlier, but we'll mention them again here. The marketplace notice is due by October 1st, so employers should be looking at that document and beginning to think about how they're going to distribute the information to existing employees, as well as set it up to be incorporated into all the new hire packets that individuals receive. The summary of benefit coverages need to be issued. Work with your health insurance plan to put that into place. If you're self-funded, you'll have to be preparing that document for yourself. FSA plan requirement maximum of $2,500 is probably well known. The W-2 reporting is largely in place, and expect to see some increasing costs as a result of healthcare reform. There are taxes and fees that get passed through to the premium rates, and depending on your health plan, these can add up to several percentage points on your premium. So we're starting to see the health insurance plans incorporate these taxes and fees into their pricing structure. And lastly, track the status of exchanges in states your employees reside. As we said earlier, these exchanges are a requirement of federal law, but they're going to vary greatly from state to state. They're going to vary in the health plans that are participating. They're going to vary in their administrative platforms. It's important that employers understand what is happening in each state in which they have employees so that they can give employees good guidance and direction relative to programs available to them. A couple of other administrative points. Determine your vacation and PTO policy will match your health benefits eligibility or differ. Meaning here is the 30-hour requirement for health insurance may not be the same requirement for other employee-related benefits or programs. So you can have something that's different or you can have them the same. Union contracts, the collective bargaining agreements, when they come up for renewal, will need to then begin to look at compliance with the Healthcare Reform Act. And then maybe one of the most important is that there's going to be a significant reporting requirement that employers are going to have to comply with. And this is that reporting requirement that I spoke about earlier that resulted in the delay of the large employer mandate. The federal government expects to release the details and guidelines on this reporting requirement either late this summer or early fall so that employers can begin to look at the information that's needed to complete this reporting and put into place the process to capture the information. The information is going to be reporting on employee coverage for the period of 2014. So this means that the information needs to be accessible beginning January 14. So an employer report can go in and pull the information necessary to provide and complete the reports beginning in January 14. The reports may not be due until January of 15. That was the original due date written into the law. But because of this whole reevaluation that's going on, we may see some different guidelines on when the reporting needs to start, what its frequency is, what the report looks like. So this is something important that needs to be looked at carefully as move through this summer and into the fall. Page 21 is a reference piece. This is the 2013 poverty guidelines that you might want to reference for the U.S., and a separate guideline for Alaska and Hawaii. And lastly, I want to just close by saying you can turn to CPE and their employee benefit specialists for information, guidance, and assistance in looking at what your healthcare reform requirements might be. And on this slide, there's a number of individuals that can be contacted at CPE, both their email and their phone number, to help you understand some of the things that are going to be required of you. CPE is fully positioned to help bring employers into compliance and help them manage their employee benefit programs. So with that, I'd like to thank everyone, and if you have any questions, please reach out to CPE for assistance. Thank you so much.